I think Sam presents this story in the same light. Julius Henry Cohen, important progressive lawyer in the New York bar, committed member of the anti-Tammany Hall reform movement, who built his reputation around his great business mediation skills. He's best known, I think, for two representations. First, he represented employers during the garment workers' strike of 1910-1911, and he brokered the first extremely important collective bargaining agreement between the employers and the garment workers. And then he's also known for his innovative approach to public-private partnerships, and he was the founder, the creator of the New York, New Jersey Port Authority. And having founded the New York, New Jersey Port Authority, he was the general counsel of the authority for a period after that. And so here's a story here we have. On the one hand, we had an organization that exemplifies a Jewish success story. Here is a lawyer who exemplifies a Jewish success story, right? He's in the thick of things, representing business, mediating, reconciliation. And yet, as Sam told the story, I actually heard a little bit of a different story, which has to do with the kinds of compromises that he had to make in order to be successful. And where I heard this was in his close relationship with Charles Boston. Okay, so here Sam shows, he quotes Charles Boston. He's clearly, Cohen is clearly very proud that he's part of this inner circle of the group who've been meeting together secretly, talking about ethics. He's very proud to be a member. He's an insider. And he quotes Boston's writings everywhere in his book. And at the same time, he's clearly quoting someone who makes the, overtly nativist, anti-Semitic comments about who should be in the bar and who shouldn't be part of the bar. And so you get a sense, I think, even though Sam didn't emphasize this, of a kind of willingness to put up with a certain amount of that in order to be an insider, in order to be successful. And for me, it resonated a bit with a conversation we had yesterday, reaction to I think it was Willie Forbat's talk, a view that when Jews were part of the civil rights movement, they were particularly concerned about representing African Americans, and being involved in other causes, but were less willing, less comfortable to represent Jews who were being discriminated against. So question there is, what kind of compromises, what kind of sacrifices, what did someone like Cohen have to put up with in order to pass, to be an insider, to be successful? Okay, so that's now the 5 minutes left. Okay, and here we have, nevertheless, in these two stories, a sort of a story of progression. Things are getting better. Yes, there's overt anti-Semitism in the early 20th century, but their Jews are managing through certain kinds of compromises, through alternative organizations, through the law, which creates this promise of equality, to get power, to shape, to transform practice of law in New York in the early 20th century. Well, boom, then we're now in the 1944, and Larry gives us a very convincing account of what motivated the passage of this anti-derivative statute that appears to come out of nowhere in 1944, the New York legislature, and which is to say that it is on shaky foundations, I think is generous. I think Larry's paper is very convincing that the sudden concern in this, with a certain kind of litigation, when that litigation was not meaningfully different from the other kind of litigation, had to be prompted by something else. And I think, and Larry's paper did a wonderful presentation here, but in his paper too, there was nothing about this kind of litigation that distinguished it from other litigation. It was no less successful than other litigation, and there wasn't actually a lot of it. And yet, what was striking about this litigation is that it involved, for the most part, Jewish lawyers against corporations, represented by Protestant lawyers. And it clearly created a certain kind of threat that was not seen in litigiousness generally, and married with the unbelievably anti-Semitic attitudes that had flourished in 1944, the evidence of who was where the Jewish bar was in 1944. I think he makes a very compelling case that is the most reasonable, best explanation for why the statute came to be. And though he didn't have time to talk about it, certainly there are. You said there was the shadow of Shylock that was over the 1995 Private Litigation Securities Act enactment. I was thinking there was a shadow of Milberg Weiss. And, query the extent to which there's the same, again, one of the things that happened, of course, is in a way it's easier to deal with, address the overt anti-Semitism in the early part of the 20th century, and to prove that it is wrong, much more difficult to deal with the kind of anti-Semitism that the record suggests is circumstantially there, that may very well have been there in the 1995 statute and may be there today in the prosecution of Milberg Weiss, which you didn't talk about, but which raises a similar question. Thank you.
Thank you, Tanina.